Case which I always tell you, this was a 52-year-old gentleman who comes to a doctor and he has got posterior uveitis. So differential diagnosis there was inflammatory posterior uveitis like VKH, posterior scleritis, or uveal effusion syndrome, or it is a very atypical CSR, multifocal CSR. Investigations were done, uveitis workup was negative, FFA showed disc leak and pooling of dye in the posterior pole, stippled hyperfluorescence. Since there was vitritis, the doctor went in favor of inflammation and started him on oral steroids at 1 milligram per kilogram body weight. And there was slight improvement, vision improved from counting fingers 1 meter to 6 by 60. And even after 2 weeks, there were not full resolutions. The doctor, though the patient says he wants to go to some other hospital, he goes to a higher referral center. There again, they say the same differential diagnosis. They feel it could be an atypical CSR. And what happens is they stop steroids. But they tell the patient that, steroids have caused problems because it could be CSR also, so you could stop steroids. So that comes in the mind of the patient. And again, multiple PDTs were given for CSR, patient were treated for 6 months, nothing happens, and then finally, in that referral hospital, patient undergoes vitrectomy with oil, the retina settles, and finally regains a vision of 612. When this is going on, after the initial presentation in the other eye, patient develops the same condition. That is when the patient is in treatment on the second hospital. And in that eye, the patient has a worse prognosis. So this goes on for 10 years, actually. So the initial doctor has treated the patient only for 2 weeks. So after 10 years, that is in 2020, this event started in 2010. In 2020, patient feels that it is because of the steroids that is started from the first doctor for 2 weeks that has created all this problem. And he gives a case for 13 crores in the National Consumer Forum. So the importance here is, you say you can give a case in the district forum, state forum, and national forum. Now we call it not forum, but commission in the new CPA rules. So here the important thing is, see, initially, where you have to give the case is based on the compensation you are asking. So if you're asking for 13 crores, you have to go to the National Commission. If it is less than 20 lakhs, you can go to the district. Between 20 and 1 crore, you can go to your state commission. But now it is not like that. It is depending on the amount you have spent for treatment. That is the basis on which, where you can give the case. So if it is less than 1 crore, it is in the district commission, district forum or commission, whatever. And between 1 and 10 crore you have spent on the treatment, then it is in the state forum. If it is more than 10 crore, it is in the national forum.
So patient has spent more than 1 crore, that's what he is telling.
No, now, before, that's the compensation he was acting.
Okay.
That is in CPA of 1986, Consumer Protection Act of 1986. I'm talking about CPA of 2019.
So
this case is given 2010.
For cataract surgery, some 2 lakhs, you can only go for the district count.
Yeah, district court, but the thing is, before, he can give a case only in the place where the cause of action has happened.
Yes.
But now it is not like that. Even in the patient's home also, suppose you are operating on a patient from Orissa, and he goes back to Orissa and thinks that I should give a case against you. He can give a court in the district, this thing in Orissa.
And you will be Aditi Toilali there, going every now and then.
And you have to go there. So that is the new thing in CPA 2019. So, okay. Now we will go to this. Now, see, the initial stand of Indian Medical Association always was, we did not come under the Consumer Protection Act of 2019 because nowhere it is mentioned. Initially, in the initial draft, it was mentioned health services. And the final draft, health services, was removed from the CPA Act of 2019. So always IMA says that, we are not coming under that. So actually, it is not like that because only 2 things that are excluded from CPA Act of 2019. One is when the service is done completely free of charge. It is not that after all the damage you say, now you don't give me any money. So I am treating you free of charge. No, not like that. All patients should have been treated free. You are also treated free. Something happens, you cannot. That is one thing. Then the other thing is something called as contract of personal service and contract for personal service. See, contract for personal service is what we and the patient are having. It is like patient, gives you the responsibility of treating him and you are using your own judgment to treat the patient. So that doesn't come, that comes under the CPA Act of 2000. Contract of personal service means it's like a driver and a master relationship. The master says you go to Patrakel, then the driver will take you to Batragal. You go to Tiruvambadi, then the driver. So it's like, so that kind of contract, it will not come under the Consumer Protection Act. So
In medical, only the first one, no?
only first one.
Ah.
So because doctor is using his intelligence, no?
Yeah, yeah.
Lot of things he is doing. So what I would suggest is, when during cataract surgery, you tell, what surgery do you want? Then patient will say, I want phaco. How would you want me to do your phaco? Like this. Which lets you, everything you give. And try to make it into a contract of personal service rather than contract for, no, I'm just telling you, it is something we can all try. And we can all say to the court that, actually we are...
Do you want antibiotic?
No, I'm just telling you. Legally, I'm telling you. Are you, with what hand do you want me, right hand or left hand? Closed eyes, open eyes, anything you can say. Another important thing is, there is something called the D.K. Gandhi case, which has come recently. What happened was, a lawyer, one guy was employed by the lawyer for a check bouncing case. Okay. And finally, the lawyer won the case for the client. And the client did not have any money to pay. What the lawyer said, what did was, whatever compensation the court gave him, no, he took it and put it in his pocket. So the client gave a case in the consumer protection saying that the lawyer has fooled me. It is an act of negligence, whatever. Now the court in that has exempted lawyers from the Consumer Protection Act of 2019. And they have said, in addition, that doctors are in the similar state. So in future, VP Shanta case has to be reconsidered by D.K. Gandhi. No, I'm just telling you. So something is, if IMA or KSOS or somebody can take it up and have a follow-up on that, probably, at some point of time, there is a chance that we can also. So they're saying is, doctors, it depends on whether it's a contract of personal service or contract for personal. So if you're giving your service like a contract of personal service, where you give all the discretion to the patient, probably, you can get away with it.
So another thing is, in the records you can write, patient doesn't want to use gas, he wants only oil. Like that, everything you can write. I do write. A patient is not willing for oil, I put gas, then it will recur. You only told, I have written. So, something that we do in retinas, but not possible in cataract surgery.
Then limitation period, I said 2 years, but that doesn't matter. It can be condoned to any amount. Then why file a national commission? I told you right now, because of the... Then confusion of differential diagnosis, multiple diagnosis, and acting upon a particular diagnosis is not considered as negligence. So that you must understand.
Yeah, that is, different doctors may have different opinion based on different studies or research thing. For example, in DME, I give laser, one person is giving injection or something like that. So it is not negligence. It is, you should have a basic supportive evidence from literature.
Why you are doing.
Why you are doing.
Even
that.
In this particular case, one doctor feels it is atypical CSR. One doctor feels it is uveal effusion syndrome. Everyone is treating it in their own line, so that cannot be. Then error of judgment is not negligence, because you are doing it with your full knowledge and reason, and you are diagnosing something, and that is not considered to be negligence. And these are two tests, that Bolam's test and Bolito's test, that is usually applied to know whether actual negligence or lack of care has happened in that particular case. Mahesh sir, you can elaborate on Bolam's and Bolito's.
The one is, Bolam test is, the court will see whether there is standard of care. There is a standard of care in the management. Like, for example, ROP. The standard of care is you have to screen this many weeks till what time, what age. So that is a standard of care. If your patient has a contract with you, and if you have not done a standard of care, and if you have done something which a normal doctor would not have done, then it becomes a positive Bolam test, and you will be negligent. Bolito test is little more different. The court will apply its own method of evaluation of the evidences.
Like
it is little more detailed.
Actually, journal evidence like that.
Yeah, joint evidence. They will have a separate medical board, and then they will assess the evidence again. That is what that case which I showed, that they did the whole records they did, and they found that the atropine was not given in time. These are all intricate dissection of the data. Supreme Court does all that.
Then last one is, how is compensation calculated? So now it has become totally different. Initially, like 1 lakh and all that Mahesh sir showed was long time before. They used something called as the multiplier method, where the annual average salary of an Indian is calculated and it is multiplied by how many years, whatever. So in the government records, it's still 10 rupees or 15 rupees. So even if you multiply it by 10,000 also, it will come only to 2 lakh. But now it is not like that. Lot of things, emotional injury, then whether the person was working, how much loss he has incurred, then court, lawyer fees, the financial, this thing, lot of things are considered and they are like given a huge amount. You have the Kunal Saha case, where the award was, that is a maximum, there were around 7 crores, 6.1 to 7 crores compensation was given, with 6% interest from the beginning. That is, the case runs for around 10 years, 15 years.
That hospital is closed 10 years back. That is different.
Yeah,
in Calcutta, Kunal Saha case.
So that is why.
So here, suppose one child becomes blind, the child, what the child would have earned in his life, which was altered by your negligence. That means the father is a doctor, mother is an engineer, the child will be a graduate and he will earn this much money for 50 years and he would have earned this much. That is the compensation. That is how they calculate.
Yeah, it's difficult. So we'll go to the next case. It is a case of endophthalmitis, and it is a typical case. In an OT, on that particular day, around 5 surgeries are being done. And all patients, they develop endophthalmitis, and all these surgeries are done by different surgeons. So one person comes to an retina surgeon, vitrectomy is done, intravitreal is given. Initially vision improves to 612, but at the end of 1 month, 2 months, it's acanthamoeba end off and patient loses the eye and it's eviscerated. Now the patient gives a case against both the retina surgeon as well as the cataract surgeon. And now I will invite Dr. Vishnu to come on stage. He is kindly consented to be the Bakra for today. And we'll just enact a scene. How in the court, questions are asked and how the doctor answers. So this will be a different thing. And this is not at all pre-planned. You can stand there also.
Oh,
okay. It is not at all pre-planned. So it is just like you are a doctor, you are going there, questions will be how naturally a person is going to ask. And I'm very grateful for Dr. Vishnu. He's my very close friend and colleague. So in the court, so Vishnu sir, now you are the whatever,
doctor.
accused, whatever. And okay, I am for a time being, I am the lawyer. And he is my colleague lawyer. He will also intervene. And those 3 gentlemen there are the judges who will, District Commission, 3 people are there. Yeah. Dr. Radharamanan sir will be designated as the retired district court judge. Remaining 2 people are eminent people in the panel. Okay, fine. So, doctor, your name and credentials, please tell.
I am Dr. Vishnu Mohanam, MBBS MS DNB.
So, how many years have you been performing cataract surgeries, Vishnu?
For 5 years.
I mean, have you had patients developing similar complications and losing their eyesight in your career?
Yeah, I had a couple of cases.
So, this usually happens to you. Whenever you operate, patients lose their vision. Is it true?
It's not like that.
No. Just say yes or no. That is all I want to know.
Yes.
Yes. See, this is how you will be caught in the court. Anybody will have end off, no, in your lifetime. You will say yes. Then you will say, okay, now Arush, now you say this end off. Then we will try to qualify. Then the lawyer will say, no. I don't qualify. Just say yes or no. Then you'll have to say yes, no. Then finish.
There was somebody was asked during the cross this thing. How many bones are there in the body?
Yeah.
You know how many bones are there in the body? We don't remember. We are doing eye surgery. How many bones are there? So you don't even know that, and you are operating the patient. They will say, okay.
Now, did you perform cataract surgery because you thought it was absolutely necessary, or patient could have gone even without cataract surgery?
It was necessary at that time. That was my thinking.
Okay. So cataract surgery was absolutely necessary to restore the patient's eyesight. Is it true?
Yes.
Does the lens become thicker once cataract is formed? Does it happen like that?
Yes.
What is the normal thickness of the average human lens, sir? Doctor, tell me. So you don't even know the normal average thickness. Now you have said that cataract lens thickens, and without that only you have diagnosed cataract. So how is it possible? You please qualify. Correct, no? This is how they ask. I mean, it is too much. then the question is, have you employed all proper protocols in your OT?
Yes, I have applied all.
Okay. Now we have gone through records in your hospital. They found that you are not registered in the Clinical Establishment Act. Is it true or false?
It's not like we have registered.
You have registered, okay. Then can dust or dirt going to the eye after cataract surgery cause endophthalmitis, doctor?
Pardon?
Dust, dirt going to the eye immediately after cataract surgery, will it cause endophthalmitis?
It can cause.
It can cause endophthalmitis.
Yes.
Now, my client is saying that, like you have promised my client that after surgery your eyes need not be covered with iPad and you could go home driving. Is it true?
Yes.
I have seen your advertisements also. It is true, no?
It's true.
Oh, so when he was driving, suppose dust has gone inside the eye. Can it cause endophthalmitis?
Yes, we have explained everything.
No.
The patient.
That is okay.
Yeah.
But if dust goes into the eye, you have only told him you can drive without iPad or anything. And now dust has gone into the eye. Can it cause endophthalmitis?
It can.
It can cause. Yes, that is fine. So my client says that after surgery you need not put an iPad. And without putting an iPad, can dust go inside the eye? Is it true?
It can.
And that can cause endophthalmitis?
That also can cause.
See, so you have told about your patient, you have not taken proper precaution. You have told you can drive, you can jump, everything, and dust has gone in and my patient has developed endoph. See, negligence is proven, no? So this is, yes.
So after that, your advocate will try to help you. Some pacifying questions.
You are the advocate,
Yeah.
you try to help him.
So Dr. Vishnu, you have operated 1,000 cases in 5 years.
Yes, sir.
Of that, except one or two, all 998 cases have got vision, right?
Yes.
Have you given antibiotic to the patient post-operatively?
Yes, we are giving it.
Given antibiotics.
Yes.
Do you have a consent form signed by the patient that endophthalmitis is a rare possibility in this thing?
Yes, we have a consent form.
So that is what.
mentioned.
So I think, respected jury, that he has taken all precautions and then signed a consent and explained to the patient. It is due to the patient's negligence that this has happened, not due to this thing.
Now the judgment is open to the jury. Now the jury can decide. Now only you can pass judgment. No one not waiting for 6 months.
I think we have heard both sides, and the doctor has admitted that he has not given proper instruction to the patient, but he could have given more instructions, but he has taken regular, normal precautions in operating and taking all the antibiotics, everything he has taken. So this cannot be considered as a negligence from the doctor's side. So he can be accepted.
Yeah. So now the option is the complainant can go for an appeal to the higher court. See, initially the appeal was you just have to pay 25,000 or half of the amount decreed. Now it is not like that. Whatever amount has been decreed by the court, 50% has to be deposited. Then only you can go for appeal. Suppose 1 crore has been, decreed by the court against you. Just to go for appeal, you have to pay 50 lakhs.
That is if the judgment is against the doctor. So now you are...
No, anyway they'll go for, anyway anybody can go for
If the
appeal.
court case is dismissed by the district court, the patient doesn't have to...
No, dismissal is different. Dismissal means...
Now the patient...
The case
complainant can go to the...
now the patient can go to the next higher court. He can go to the state commission for appeal.
He doesn't have to pay anything. But if the judgment is against the doctor and you have to go for an appeal in a state forum, you have to have, if they say that 5 lakhs or 10 lakhs, half of it you have to keep
Pay
as court fee.
for this thing. That's what.
Another question is, suppose there is a purposefully defaming a doctor or hospital, purposeful, and that is established in the court, whether the doctor can go against the patient.
Yeah, that is a totally different thing. That's a defamation suit. But the problem with defamation suit is you are claiming 10 crores, you have to pay 10% of that in the civil court. Then only you can go for a case.
I will also answer. Actually, defamation you can file in the court. They may not admit it at all. Okay, because you have to give enough evidence. that because of this, patient's defamation, I lost my practice, now I am having so much loss, then the court may admit. And if you can't ask crores and all. You
can, but 10% you have to
10% you have to
do.
do. So I literally went against a patient to admit, file a defamation case. But these were the problems. I just dropped it later.
Okay, I think time is over now.
Any comments? We'll have few interesting.
Yes, interesting comments.
Yeah.
Lawyer tells you to answer yes or no. Are we obligated to answer only yes or no, or I can qualify with a couple
No,
of
you can
sentences?
qualify, but the lawyer will say, doctor, I told you only yes or no. Or you can probably keep quiet. That is the one option you have.
No, because if the questions are put in such a way that this yes or no.
You
can
look
be-
at the judge and tell that, sir, respected your honor, this cannot be answered in yes or no because it requires an explanation. Please allow me to give the explanation.
Yes.
Mostly,
The judges intervene.
in our court, most of the lawyers are also very bad in English. Suppose you talk in a good English, looking at the judge, you will allow.
Okay.
This is another small trick.
I think this thing happened many times to me, and 100% of the times judge allowed.
Judge will allow you. You can give an explanation. Yeah. Madam.
How many? Myself.
Madam, that nowadays the studies show that you don't need preoperative antibiotics, even though some judgments are there that without giving antibiotics they operated. You can, your hospital policy is enough, madam. Whatever you have written in your SOP, that is enough. If I give it for 2 weeks only because it can cause resistance, that is enough. That is our hospital policy. You have operated thousands of cases without any complication, that is it. So, there is no strict, another thing is how many cases you can do in a day. This was a big issue. Srinivas
Yes,
telling,
yes.
AOS has told this many. But the problem is, suppose the 16th case has death or endophthalmitis, like this Shankar Nataraj case, there will be this thing. So, AOS says 30 cases or something,
think
no?
so, yeah.
Something like that. Yeah?
I just have a last question. What if that case of 13 crores and you don't have money to pay and all your legal documents have been given to them, all summed together, it's not coming up to 13 crores, and what do you do next?
Bankruptcy.
File for bankruptcy.
Bankruptcy.
Yeah, that's possible, no?
That's possible.
File for bankruptcy. Before that, shift all your FDs into some charitable society
All
and
your,
then something like
You have got an insurance, right?
Yeah, insurance is there. They will. But 13 crore and all, nobody
13
covers.
crores is nobody covers.
Mahesh, just because the patient demands 13 crores doesn't
It doesn't mean,
that's what-
anything.
Now, currently, the
Patient can
highest
demand anything, no?
highest is 7 crores in that Kunal Saha
That is
case.
because death
That
has
was a
happened and that is gross negligence also. So that's
No,
different.
no, like she was worried about the 13 crores.
No, don't worry. It's okay.
Okay,
Sir,
so,
the last, sir, that ROP, then you have to keep it for 20 years,
yeah.
20 years.
What is the problem? You have EMR, no? It will be lying in the cloud, no problem. That's why all of you changed to EMR.
I think for anything you keep it as long as possible.
Because
That's
the other
not
one will
order
get, after 4 or 5 years, it will get crumbled and chedalerikum.
No, because you can't, when patient comes with the case against you, you don't know what is only happening. And you can't say to the court that I am supposed to keep only for 3 years. Nobody will allow it.
We can take our EMR, but once you are going to multiple hospitals and all, you never know how they are keeping it. That's what.
Okay, thank you very